The standards are very clear,
Okay.
and in some situations, I suppose the facts can be murky, but I actually don't think it's
Yeah.
that.
Okay,
I
you
mean,
don't think it's
the,
hard.
The cardinal rule is you may never punish speech, and by punish that includes any kind of restriction or sanction or regulation, solely because of disagreement with the message. So, people debate, is from the river to the sea advocacy of genocide? It doesn't matter. You can expressly advocate genocide. That is protected expression. Let me be very precise about this, Doug. Unanimously, way back in 1969, in case involving a KKK speaker who was advocating violence against Jews and blacks and government officials, the court unanimously issued a holding that every single justice since then has agreed with. Think about that, all of the ideological diversity.
That's staggering.
And
that never
yes.
happens, by the way.
And they said advocacy of violence or lawlessness is protected. It only crosses the line when it's not just advocacy, but it's intentional incitement. And there's a difference between advocacy and incitement, right? And not only does it have to be incitement versus advocacy, it has to be intentional, and it has to be inciting imminent violence or
Now,
lawlessness.
in that day? Or
It's got to be immediately.
Yeah.
That is likely to happen imminently.
Okay.
And excellent question, what does imminent mean? The Supreme Court had a subsequent case that involved an anti-Vietnam War demonstrator who said to his followers they were having some disruptive demonstration. The police had cleared them away, and he said to his followers, "We'll take the fucking streets later." And the Supreme Court said, by indefinitely talking to later, that fails the imminence requirement. There was another case the Supreme Court decided involving an NAACP speaker who was rabble-rousing his followers to boycott merchants who were allegedly discriminating against black people. And he said, if any of you violate that boycott, we're going to break your damn neck. And there was some actual violence days later and a week or so later against boycott violators, and the Supreme Court said that fails the imminency requirement. So I think these standards are hard to satisfy. That said, I would say there's one standard that is that we haven't talked about expressly that is relevant because it's being enforced now by the Department of Education, Office of Civil Rights, and also in some private lawsuits, and that's the concept of hostile environment harassment under Title VI of the Federal Civil Rights Statute. Any educational institution, public or private, that gets government money does so on a number of conditions, and one of the conditions is that it must respond immediately to or promptly to complaints about hostile environment harassment, which consists of a pattern of conduct, including expressive conduct, that is objectively offensive and so severe and pervasive that it deprives the targeted group of equal educational opportunity. And complaints have been brought on behalf of Jewish students and faculty members against a number of campuses that they are facing hostile environment harassment. And the reason that's a little bit more murky because you've got to look for an overall pattern, and when each individual instance can't be punished on its own, but maybe in the overall context the university has an obligation to take some mitigating action.
Yeah, that's complicated, and it's tough for the law to handle all that.
I should say,
it's tough.
The Department of Education has said that some of its complaints are all that it has brought, which are confidential. I mean, it announces that it's brought the complaints, but it doesn't give you the details. it has said that some of them are based on Islamophobia and discrimination against Arab and Palestinian students, as well as Jewish students and
Okay.
Israeli students.